Now, moving away from sports, a person who intimidates, willfully insults a judge or witnesses during court proceedings will face jail term of up to 6 months or 200,000 shillings fine after President Uhuru Kenyatta signed a contempt of court bill into law. The bill recommends punishment of offences such as assaults, threats against a judge, judicial officers or witnesses. Previously, the preserve of punishment of contempt of court proceedings had been of the High Court, but the new law empowers both the High Court and the Court of Appeal to punish. And we now would like to move on into that interview. And joining me now is Mark Ndongo, who is an advocate of the High Court. Good morning.
Morning.
And thank you for joining us on Christmas Eve.
Yeah, thanks for having me.
Yes, now maybe let's just understand this bill that has now been signed into law. What difference does it make? Apart from the fact that, of course, it moves it just from the Supreme Court to also the Court of Appeal.
For the first time, we are having a situation whereby we have a written law that tackles issues to do with the contempt of court. Previously, we just had Section 5 of the Judicature Act and Section 121 of the Penal Code that dealt with offences before court that may be deemed to be contempt. But now, for the first time, we have some law that even stipulates the fines, defines the offence of contempt of court, and stipulates a guideline on how the court should proceed with punishing offenders who are deemed to have committed contempt of court.
Okay. Previously, before now this was signed into court, who is it that would actually now take action of contempt of court? Because we look at some cases possibly where there has been contempt of court, but not much has been done.
As to how you execute orders of court relating to contempt of court, that has been quite an issue because
it's been shaky.
It has been shaky a bit because sometimes when decisions are made against people who are senior in the executive, it still goes back to the executive to enforce those orders.
Right.
So that has been quite an issue. But we have been seeing a lot of success in terms of civil, the civil manner of contempt of court. That has been a bit more successful, as in between parties who in civil proceedings do not comply with court orders or court directions. That has been quite successful in the past, and even now with the coming in of the new act, we just expect more success in that line. As to orders that are disobeyed by the executive, that is still an issue.
It's still an issue. Forward. And of course, the main issue here would be how can one, go against the executive, yet the instruments of power, as it were, are kind of under the executive, especially when it comes to implementing, because all the court can do is rule. Yes. But the implementers now, like the police force, are under the executive. Yes. Does this bill now deal with that?
Still, we have, those are issues of implementation. And issues of implementation are not so much about how many times you legislate or how many times you come up with laws or regulations around it. It is about the goodwill. Sometimes it's the political goodwill. Sometimes it's about the judicial officers being hard enough and following up on the orders that the court issues to just ensure that as much as possible they're executed. Okay. Such that we do not have an issue whereby judges are getting worn out because they are feeling as if they are powerless.
They're powerless.
Yes.
But now, let's look at some cases possibly so that we can understand fully what the difference between then and now. And there's a case many of us will remember where we had a ship that was blown up in Mombasa, and this was against what the court had ruled. It was an exhibit as far as the court was concerned. And I think we did have the minister, the CS for Interior, Joseph Gaiseri, in contempt of court. Yes. But nothing has been done so far. Does this bill now rectify a situation like that? Or maybe let's start with, first of all, why has nothing been done? Or why had nothing been done?
In terms of why nothing has been done, I think it's a plain issue of execution of the order, which basically someone has to be brought before court. If it is a CS, the cabinet secretary, he has to be brought before court, either arrested or on his own volition he comes before court. But that is not foreseeable. So that is still an issue. In terms
Does this bill now rectify that? Because I'm trying to look at a point where, let's just take an example. For instance, if we had an IG in contempt of court. Yet he is the same man in charge of the police force. And it would be the police that would be expected by the courts to implement or enforce that particular order. How does that work out?
There's still a gap. There's still a gap, and the gap is not in the law.
It's not in the law.
Yeah, in fact, the bill as worded is good enough to work in such kind of a situation. But we still go back to the implementation.
And why is the implementation a challenge?
It is because, you see, as courts give orders, they do not have their own police or police who are tasked to. Yeah, we still go to the same unit that is to a large extent controlled by the executive. So the willpower, be it political, is still an issue when you have to execute orders against the executive. Okay. So that even moving forward, it does not matter how many laws we come up with. In that respect, it is still going to be a challenge moving forward.
It's almost like saying that you arrest yourself somehow.
And,
or to have your to have your juniors arrest you,
Yes.
which obviously would not be seen, especially with the discipline forces, because they have a certain chain of command, and it's almost unforeseeable for a junior, as it were, to arrest a senior if the senior is the one who's in contempt of court.
Yes.
Okay. So what difference really does this bill bring on the table?
For the first time, we have the offense is clearly defined. Before then, we had it defined in case laws, decided cases. Now we have it stipulated, and we have fines for that, and we have a procedure. In terms of the fines, we are looking at a period of 6 months maximum. In terms of imprisonment,
6 months.
6 months. In terms of the fines, a maximum of 200,000. And if the court considers that there are good grounds for you to be imprisoned and as well to be fined, it can as well give orders for that. And it has also clearly defined what the High Court can try for contempt of court and what subordinate courts can try for contempt of court. And as well, it has entrenched the principles of natural justice within the trial for contempt of court. Of course, with the coming in of the new constitution, issues to do with fair administration of justice, fair hearing, and Article 47 and Article 50 of the Constitution. So that has been taken care of. Issues to do with, there's contempt that arises when the court is proceeding. That is what we call contempt on the face of court. So in terms of how do you move from someone has committed that offense before court as the court is going on, and how do you try that? So there are provisions, like for instance, you can be arrested as the court proceeds. You can be put in police custody, and before the court adjourns, for that sitting in which you are arrested, you are given an opportunity to, first you are informed why you have been arrested. Number two, you are as well given an opportunity, you can give your own defense, and as well over and above that, you can as well be given the next directions on how you are going to be heard.
Okay.
So the issues of natural justice have been well taken care of.
They've been well taken care of. Now, this, of course, when I looked through some of the bill that come under the bill, it seems it has a lot to do with publications. Maybe you can explain that a little bit for us to understand.
The bill, to a large extent, has concerned itself with issues of publication, publication of court proceedings that are ongoing, in terms of how do you report on a matter that is before court. So there are very strict provisions on how you do the reporting. To begin with, any fair and accurate reporting of court proceedings is allowed by the Act.
Okay.
That is for ongoing proceedings. For proceedings that have been terminated or that have ended, a fair comment is allowed under the Act. Now, in terms of where we are moving from the time before when we had the Act and now, one of the changes that we see is that for journalists who are taking court proceedings before, you didn't have to seek the leave of court. Now with the new Act, you need to seek the leave of court to either record court proceedings or even take a record of the documents that are contained in the court files. So that is going to be quite an issue in terms of looking forward, in terms of how we implement that.
Okay.
We, of course, expect that some regulations are going to come in because the Act has already taken care of that.
Okay.
And we await the coming in of those regulations to just see how the Act is going to be implemented.
All right. And there was also now the question of having other courts that can now, also enforce this. Is that different from what was there before? Previously, it was just the High Court that was able to implement this. Is it now making it more accessible for maybe the judiciary to use it for contempt of court?
Yes. Now, subordinate courts, which are the lower courts now, are able to punish for contempt where court orders have not been obeyed, which are court orders that have been issued by the same court, and, of course, contempt on the face of court.
Okay.
For instance, if you intimidate, if you harass, if all that kind of manner of treatment against either a judicial officer, that could be the magistrate himself or herself, it could be the court clerk, it could be the witnesses before court. All those, now the lower court can be able to do that.
Okay. The main difference that this bill makes that now it is signed, what really does it bring on board that was not there before?
We have offenses. They are clearly stipulated now. As to what constitutes a contempt of court, that is now a lot more clear. Although the bill as well, the Act as well appreciates that contempt of court is a lot wider than is in the Act. We now have the procedure that a court can use in trying someone who has committed contempt of court. We also have a provision on the powers of subordinate courts to try people for contempt of court. The other addition possibly will be in terms of companies, state organs, and other natural persons. There is now a provision on how they may be held accountable for contempt of court. Like the accounting officers in respect of parastatals, government ministries, they are the people who would be held accountable on behalf of those bodies. In terms of companies, if it's a company, the persons who are in charge of the company, the managers, the directors, can be held accountable for contempt of court. Okay. So those are some of the provisions that we have seen that are going to just make the implementation of the Act a lot better, and to have some certainty in terms of how courts are able to punish people for contempt of court.
Contempt of court. Okay. As we finalize, looking at the publications and the fact that when a case is in court, there are very strict guidelines now in this particular Act that guide how you can publish or what you can say or cannot say. Is that likely to maybe scare or remove the authority that possibly one has to publish? And this is publications here, of course, is not just talking about media. It's also talking about anybody who's maybe on social media and referring to a case in court. Is that likely to remove a bit of weight on what one can publish?
Yes, quite a bit. For instance, you can't publish on court proceedings where the court has pronounced itself and said that these proceedings should not be made public. So that is one of the situations. Number two, you can't publish court proceedings without the consent of court.
Right.
So that, I think, for journalists moving forward, that is something that we expect. They will be seeking for leave at all given times they want to take up court proceedings. In terms of even advocates, in the past, like we have been able to extract court proceedings and when the proceedings are still before court. That as well is going to be curtailed to some extent because whether it is the use of electronic media, maybe the use of a phone to take a snap of the court proceedings, that now is illegal as per this act, unless you have the leave of court.
Okay.
So those are some of the things moving forward that we are going to expect to see how they are going to be implemented, and of course the compliance by parties who use the court services.
All right. Thank you very much, Mark Ndongo, an advocate of the High Court there. Just making it clearer what this means when the bill in contempt of court was signed by the president yesterday and what that is likely to have an effect on us. But maybe just last question, some of those, this cannot be applied retroactively. Can it be applied to cases maybe that had not been dealt with before this?
It cannot be applied to cases that have been
that are already passed.
That have been determined before then. But moving forward, as soon as the act comes into operation, it will kick on after then, because the principles of natural justice are that you cannot be held accountable for acts that were done and had not been defined at that point in time, yes.
All right. Thank you very much, Mark Ndongo, an advocate of the High Court there, just making it clearer some of the bills, or rather the bill that was signed into law yesterday by the president, and that's in contempt of court. Now, this is News Center, and we're going to take a short break, but do stay with us right here on KTN News. We'll be back with more stories that are making headlines right here.